Hi, everybody. I'm Brittany Lewis, a breaking news reporter here at Forbes. Joining me now is Ilya Somin, law professor at George Mason University. Professor Somin, thank you so much for joining me.
Thank you for having me.
You and I talked last month about the lawsuit you and the Liberty Justice Center filed against President Trump's tariffs. To start off the conversation, before we get into any updates on the case, if you could lay out the suit, exactly what it says and what your case is for us.
Sure. So in April, President Trump started the largest trade war since the Great Depression by applying 10% tariffs to virtually every country in the world, plus some additional so-called reciprocal tariffs. And he's doing all of that under a 1977 statute known as the International Emergency Economic Powers Act. And there are a bunch of reasons why we and our clients argue that this is highly illegal. First of all, this is a statute which doesn't even mention the word tariff or any synonym like imposts or duties or the like. So we argue simply that this statute doesn't authorize tariffs at all, and no previous president has used it to impose any kind of tariffs, much less the biggest tariffs in many decades. Secondly, the statute says that you can only use the statute at all, whether for tariffs or anything else, if there is a national emergency. And we say there's no emergency here because an emergency is supposed to be some sort of unexpected crisis. The claimed emergency here is trade deficits. And trade deficits, as actually the government admits, have existed for decades. They're not a crisis. They're not an emergency. They're not even necessarily any kind of problem at all. Most economists will tell you that trade deficits are actually not actually a problem for the economy. Let's assume, however, there is an emergency. In addition, the statute says that this emergency must be one that poses an unusual and extraordinary threat to America's economy or security. There's nothing unusual about trade deficits. They exist all the time. They're not extraordinary. They're perfectly normal. And they're not even a threat at all because trade deficits, generally speaking, are not harmful to the economy. Again, most economists will recognize that. You can readily see this from even a simple example, like I have to admit, I have a trade deficit with my local supermarket. I buy things from them all the time. They virtually never buy anything from me. Do I wish they would buy some copies of my books? If they're listening, please come and buy some of my books. But even if they don't, it's not an emergency. It's not a threat. It just simply represents that I value the things that I can buy there more than I value the money that I pay for it. And I prefer to buy from them and go through the effort of growing all my food myself. Similarly, there are things that we can buy from Canada or Europe or other countries where we value them more than the money we pay. And it makes sense for us to buy them from those producers than to try to produce everything ourselves, which would be wasteful and costly and create all sorts of other problems. In addition, let's say somehow there is an unusual extraordinary threat or that the president just has under this statute, as he claims, he claims a power to impose tariffs on virtually any country for virtually any reason. Then you have what the Supreme Court calls the major questions doctrine, which is the idea that if the executive claims the power to decide some major political or economic issue, then at the very least, Congress has to clearly delegate that to him. And here, it's very obvious there's no clear delegation of any kind. It's not even clear if tariffs are authorized at all. If not, it's not clear that there's any kind of emergency or extraordinary unusual threat. We actually think that it's clear that none of those things exist, but at the very least, it's uncertain, and that uncertainty says that under major questions doctrine, the courts have to rule against the government. You might ask, is this a major question? I would say if anything is a major question, this surely is. That what we have here is over the next decade, this will impose something like $2 billion of extra taxes on the American people. This makes everything else the Supreme Court has ever said is a major question seem small by comparison. The biggest thing up till now was President Biden's $400 billion student loan forgiveness, which I think the Supreme Court rightfully struck down a couple of years ago. But even that seems minor and relatively insignificant compared to this huge trade war, which is several times that size in its impact. Finally, let's say you set aside all those other issues. Then there is the constitutional non-delegation rule, which says that there has to be at least some limits to the amount of power that Congress can just delegate to the president. And if non-delegation imposes any constraints at all, it surely must constrain what Trump is doing here because he's essentially claiming the unilateral power to impose any tariffs of any size on any country for any reason for as long as he wants. Again, if that is not a non-delegation problem, I do not know what is. We finally have a technical legal argument based on the constitutional avoidance doctrine. The Supreme Court says that if an interpretation of a federal statute raises constitutional problems, then where at all possible, if there's a plausible interpretation that avoids those problems, the Supreme Court and lower courts should adopt an interpretation that avoids it. Here, if they were to rule in our favor on any of those previous four issues, they can avoid the non-delegation problem and don't have to address what would be the biggest delegation power grab by the executive, the biggest claim delegation since at least the Great Depression. So we have 6 different pathways to victory. All we ask is that the courts give us one of them.
So yeah, you gave 6 different pathways, as you said there. You just need one to win here. The Court of International Trade heard arguments on the case earlier this month. Can you talk to us a little bit about the hearing?
Yeah, so a number of issues were raised in the hearing. I think a big takeaway is that the judges are not comfortable with the president's claim to virtually unlimited power. And that same issue arose today in the hearing on a similar case filed by the state of Oregon and 11 other states. And today, Judge Rastani said that, under the government's interpretation of this statute, there's no limit, and any crazy thing, her words, not mine, would be permissible. I hope, I don't know for sure, obviously our arguments are not a perfect indication of what courts will do, but I hope she and the other 2 members of the panel will recognize, as they seem to, that that's an implication of the government's position, and that implication is unacceptable under the statute, under the major questions doctrine, and if necessary, if they reach that issue under non-delegation.
I know that you don't have a crystal ball and there's no, you can't predict exactly where their heads are at, but based on what they were saying, based on the questions that the judges were raising, I mean, where do you think their heads are at right now? Because essentially, as you said, you have 6 pathways, but what your suit boils down to is that IEEPA doesn't grant President Trump the ability to invoke tariffs, and there's no national emergency. Trade deficits don't qualify as a national emergency. The DOJ argues that IEEPA does give the president broad authority to invoke tariffs, and that trade deficits are a national emergency. So what questions were the judges asking that indicated to you, hey, maybe they're on our side, maybe they're trying to poke holes in our argument?
So I think it's, as you say, it's always dangerous to make definitive predictions based on oral argument. And I can't read the judges' minds or read anyone's minds other than my own. But I will say, that oral argument plus the one today that just now concluded, they both suggest that the judges are not comfortable with this claim to unlimited power, that they think they should have at least some ability to review what qualifies as unusual and extraordinary. They also think that the major questions doctrine quite likely applies, and either of those are a way that we could win, and probably the state lawsuit could win as well, that lawsuit is somewhat broader in its focus than ours, and it also attacks some tariffs that are not included in our lawsuit. So I think it seems to me likely, though not certain, that this court will not accept the administration's claim to unlimited power. As to which of our 6 pathways is the one that they will accept, I honestly don't know. And obviously they won't have to rule on all of them necessarily. If they give us one and give the states one, then they don't even necessarily have to address all the others if they don't want to. But it seems to me, if I had to guess, and this guess could easily be wrong, I think they clearly think that this trade deficit situation is not an extraordinary or unusual threat. And also they think, I believe, that the major questions doctrine likely applies and that the statute, and if it does apply, we and the states should win. In response to government's claim, that this is clear, today Judge Rastani said, well, if it's so clear, why are we having all these arguments about it? And it's certainly not clear to everyone. And I think it's very obvious, at the very least, that the authority that the president is claiming here, sweeping authority to impose whatever he wants, it's at the very least unclear that the statute grants this, though again, we would contend that it's actually clear that the statute doesn't give this authority, but at the very least, there's uncertainty here. And under the major questions doctrine, that uncertainty means that we should win.
I want to talk about that national emergency just a little bit because I've heard that comparison before, that I'm in a trade deficit essentially with my store because I'm buying goods from them. They've never bought anything from me, therefore I'm in a trade deficit with them, and that doesn't constitute a national emergency. That's the argument. When the DOJ said that trade deficits equal national emergency, I mean, what were the judges saying? Did they intimate that that could be a slippery slope?
Yes, absolutely. So in last week's oral argument, Judge Rastani said, well, could the president say that a peanut butter shortage is a national emergency and then impose any tariffs he wants as a result? And she's right. There is no limit. Today, she pointed out that under the government's position, you can do any crazy thing. Again, her words, not mine. And that's true. I would merely say that her example of the peanut butter shortage is actually more of a genuine problem, potentially at least, than the problem the government is actually citing here, and that trade deficits are not really a problem or an emergency at all. As to peanut butter, there are at least a lot of people who really like peanut butter, and they would feel bad in their diet, the quality of their diet would diminish perhaps if there was a peanut butter shortage. So while I don't think that would rise to a true emergency or an extraordinary and unusual threat to the American economy, it would at least be a real problem with trade deficits or not.
And have these businesses that are part of this lawsuit, there's 5 businesses, have they suffered real tangible damages yet from these tariffs? Because the DOJ is saying essentially, hey, they haven't, had any real loss yet from these tariffs.
So they clearly have. In our filings, you can read about how our clients, like many other businesses, they need to maintain ongoing relationships with suppliers, with customers, and others, and those relationships are already being disrupted. If the president can impose any tariffs he wants, anytime he wants, it's impossible to plan ahead for businesses and others, and it's impossible to maintain on those ongoing relationships. So our clients are already beginning to suffer losses, and obviously those losses will continue and get much worse if these tariffs are allowed to stay in place. If you want to talk about the legal standard of irreparable harm, we're not required to show that irreparable harm has already occurred. The whole point of getting a remedy in court is to prevent future harm from occurring. And I think there's little doubt that these tariffs will impose enormous future harm, both on our clients, on numerous other businesses around the country, and greatly increase prices for American consumers of all sorts of goods. That's just basic economics 101.
And as you noted earlier in the conversation, there are already a handful of other lawsuits against President Trump's tariffs. The Court of International Trade, the court that heard your case last week, just today, as you noted, heard the arguments of a dozen state attorneys general suing over Trump's tariffs. Does that bolster your case, do you think? Does that impact your case at all, that there are this slew of other lawsuits coming after President Trump's tariffs?
I think it certainly helps. It shows that there's a wide range of different people and groups with different views, perspectives, and interests who are harmed by these tariffs and want them struck down. Moreover, the different cases raise, in some cases, somewhat different arguments and issues, and that gives courts a broader range of opportunities potentially to strike them down. Though there's also a fundamental commonality between our case and all or most of the other ones, which is quite simply, the president is claiming virtually unlimited power to impose tariffs, and that is wrong under the statute. And if the statute did grant that power, which we say it doesn't, but if it did, it would be unconstitutional. And that issue is common to virtually all these cases, with the possible exception of the Montana Blackfeet case, which we can talk about if you're interested. But that one is sort of unusual because it's much narrower than the others.
And since you and I have last talked in April, we've gotten two major trade developments. President Trump unveiled details of a framework of a deal between the United States and the UK, and the United States and China agreed to a temporary 90-day pause while they hash out the rest of their negotiations. Does that impact your lawsuit at all?
Not to any significant extent. First, even with the deals with the UK and China, we still have record high tariffs, at least for the last 80 or 90 years, in virtually every other country in the world. And even with the UK and China, first of all, these deals still leave the tariffs at a much higher level than they were before Liberation Day. In the case of China, all tariffs are still at 30% against Chinese goods, which is much higher than before, and an insupportable level for many importers, including some of our clients. And even the reduction from the level of 145% that only lasts for 90 days. With respect to United Kingdom, we still have 10% tariffs on all imports from United Kingdom. That compares to about 3.3% on average before Liberation Day. So these deals make a horrible situation very slightly less horrible, but only slightly, and the president is still claiming and wielding this vast, unreviewable power that he has no actual right to.
And then my final question to you, and as we noted earlier in the conversation, you don't have a crystal ball. You can't look into the future here, but what do you think is next for this lawsuit? Do you think it makes its way all the way up to the Supreme Court? And if so, does that concern you that the Supreme Court is more conservative leaning, there are more conservative justices? I mean, do you foresee it going that far?
So it could go that far. The next step, most likely after the Court of International Trade makes a decision, is that whoever loses will appeal to the U.S. Court of Appeals for the Federal Circuit, which is the Court of Appeals that reviews cases from the Court of International Trade. Whoever loses there could potentially try to appeal to the Supreme Court. The Supreme Court, of course, gets to decide what cases are on its docket. We can't know for sure that they would get there. It's possible that our case or one of the other cases challenging the tariffs, or all of them perhaps, or more than one, would get to the Supreme Court, given the importance of the issue. I can't be certain what they would do if it got to them, but I think we would have a strong case to present to them, including based on the jurisprudential principles that the conservative majority has itself advocated. Many of them are sticklers for statutory text. The statutory text simply does not give the president this vast, unreviewable power that he claims. And in addition, the conservative court has expanded and elucidated the major questions doctrine that I mentioned earlier. If the major question doctrine has any meaningful validity, it surely applies here. And several of the conservative justices, such as Justice Gorsuch, for example, have said that they want to strengthen the non-delegation doctrine, but even a modest, relatively weak non-delegation doctrine that both conservative and liberal justices have accepted, it would bar, I think, the virtually unlimited claim to delegated authority that the government is making here. So obviously, I can't know for sure what the Supreme Court will do, or even if they would be interested in taking the case. But if they do take it, I think we have a strong argument based on the jurisprudential principles that members of the Supreme Court conservative majority, and sometimes the liberal justices as well, have elucidated in previous cases.
And if we see, and when we see rather, developments in this case, I hope you come back on and fill us in. Professor Somin, thank you so much for joining me. You're welcome back anytime.
Thank you. I'd be happy to talk.